All right, everybody, we're going to get started now. So thank you very much. I really want to appreciate and say thank you to every single one of you that has shown up today for our Mastering the Offer webinar. I'm Geoff Rabideau of Rabideau Law. I trust you all know me. So thank you for being here and let's get into this. So what I'm going to be teaching you is the tips and clauses that every winning realtor should know. And what we're going to be covering today is we're going to be covering certain clauses of the agreement of purchase and sale. So specifically, we're going to be covering clause 2, the completion date clause. We're going to be covering clause 10, the title clause. We're going to be covering clause 26, the agreement in writing clause. And we're going to be covering in Schedule A standard clause that you all know, warranties, seller represents, and warrants. Okay, so your warranty clause. Starting off with clause 2, which is the completion date clause, which you all know, the seller agrees to provide vacant possession no later than 6 p.m. on the day of closing. That's the standard wording that we all know from the agreement of purchase and sale. But what does that really mean? The agreement of purchase and sale says no later than 6 p.m. However, that doesn't mean that the seller gets to stay in the property until 6 p.m. What it means then is that the title of the transfer has to be completed no later than 6 p.m. So therefore, if the title of transfer is completed at 2:41 p.m. in the afternoon, then that means that the seller has to be out no later than 2:41 p.m. on the day of closing. Now, the hard part is, and I've had this happen where have been some instances where the clause was misunderstood, and not typically by my clients, because I tell all my clients here at Rabbit Law that, hey, you guys got to be out no later than noon on the day of closing. But I have had it where my client has gone to purchase the property and got possession of the property and went to the property, and the actual seller was still there. And that's because the seller, in that case, was not advised by their lawyer that they had to be out at the time of closing. And so therefore they have often said, well, I have it until 6 p.m. No, and that's where it's a mistake. They actually were supposed to be out at that time of closing. And so in this instance, the one scenario I can think of, I had a client who wanted to move in. He got quite frustrated. He called me up. I called the other lawyer, and the other lawyer said, well, hey, there's nothing we can do. Our client is just on moving out. Just let them be, give them some time. Obviously, explaining that to my client is not helpful. So what I said to my client is either a few options you have is one, go have a meal and come back, or if you prefer, maybe you give them some help to move out. This way you can get in sooner. Neither option is helpful. Neither option my client preferred, but my client understood that at that point, it's very difficult and very limiting of what we can do on their behalf, right? Call the cops. The cops said it's a civil matter. The cops are not get involved. There's no trespasser in their minds. And the other option is in order to force the seller out, you have to look at bringing a court application. Well, a court application would take days, weeks, and a lot of money. So in that case, in this instance, my client, had decided to help them move out and try and get them out quicker, get their stuff out of the property so they can move in. So that's important. And it's important to know that even though it says no later than 6 p.m., it's at the time of closing. What's important to also know is that the land registry office closes at 5 p.m., which means that we can register the transfer up until 5 p.m. Now, if the transaction closes after 5 but before 6, we can still complete it. This is what's called an escrow closing. So which means as long as the purchasing lawyer has sent the money to my trust account and the money is in my trust account and I can see it before 6 p.m., then what I can do is I can complete the closing in escrow, which means we then say, hey, fine, we're going to register the transaction first thing in the morning. And what we would do then is we would give the keys to the purchasing law firm and allow them to release the keys to the purchaser. The seller, in that instance, we just have to explain, hey, it's closed, and you'll get your money the first thing the next business day. So obviously, if we're closed on a Friday, they'll get their money on the Monday, sent to them on the Monday, or they get it the next morning, the Tuesday. Okay. But that's typically what happens in that case. And the escrow closing is possible. It's just we can't register at that time because it's after 5 p.m. when the land registry office closes. Now, the reason why this is all important, and this is especially important with this clause, is when we're talking about clients that decide to sell a property and buy a property on the same day. So it is important to know that when a client sells a property and buys on the same day, they don't have bridge financing, then what we need is we need the money from that sale in order to purchase that property. Okay. So therefore, if that sale is delayed, then their purchase is delayed. And so, and it's also important to know that when a sale is completed, we then have to turn around and send that money to a new law firm, and wires do take about 2 to 3 hours. So if that sale doesn't get completed until 4 p.m., it's highly unlikely, it's potentially unlikely that we're going to get that purchase completed by 5 p.m. or 6 p.m. Now, once again, depends on who the other lawyer banks with, right? Or if we quickly can run the money over to them or get to the bank in direct deposit in their account, if they allow that, because some law firms do not allow direct deposit in their account. So, and we've had this happen in an instance where I had clients who were selling their property. They had moved out of the property, everything was packed up, and they were out of the property as of noon on the day of closing, which I always do ask my clients, please be out on noon of the day of closing. And so they were with their moving truck, their vehicle, their 3 kids, their 2 dogs, their cat. The party purchasing their property was unable to close. So up until 5 p.m., or 6 p.m., nothing. The other side was unable to close. And our clients were in the difficult situation of what do they do now? Because they couldn't complete their purchase. And they now had nowhere to live. And all their possessions were in a moving truck. And they have movers. A very difficult situation. So what they did is no hotel is going to take 2 parents, 3 kids, 2 dogs, and a cat. So they had to turn around rent an Airbnb, which is pretty expensive. And obviously our clients were quite frustrated with this process. So they went, we were able to get them in the property on Monday. We received the purchase funds on Monday. We turned around and then purchased their property on Monday and got them into the property. But that was quite an expense and a lot of frustration, a lot of anxiety, and a lot of difficulty for them over that weekend. So it's always best to, in this case, get bridge financing. Now, bridge financing would allow us to have completed their purchase at the same time as their sale, because they would not, like, if you're selling without bridge financing and purchasing, then the two are linked. But if you're using bridge financing, they're two separate transactions that are not linked. We could have received those monies in for the purchase. We could have got the purchase completed. The sellers, my clients, would have been able to move out of their property, move into their new property, and not had been as a difficult situation as it would have been because they had already moved into that new property, right? But last, they didn't have bridge financing. And the reason why I mention this is because as realtors, you're one of the people to contact the clients at the very beginning. And so if you see they're going to be putting an offer in on a property to sell and close on the same day, I would implore you to please mention to them that bridge financing. They need to get bridge financing. It is so beneficial. Now, a lot of people's concern with bridge financing is the cost. They think, oh, it's too costly to get bridge financing. Well, bridge financing is actually typically about $250, a fee of about 250 bucks plus interest. And so if they're selling and buying on the same day, it would just be the $250 plus 1 day's interest. And that cost is probably less than it would be if in the event you didn't have bridge financing. So let me explain. When you don't have bridge financing, you have to be out of your place no later than noon. Let's say the transaction closes at noon. Okay. Well, we get the money, we close the sale, we turn around and buy the property. We wire that money to the other law firm. Wires take about 2 to 3 hours. So we wire that money to the other law firm. The other law firm then completes sells the property to us. We get it complete. That's about a 3 hour window where our clients are homeless. And in that 3 hour window, our clients have a moving truck and movers just sitting around, provided they're not driving somewhere far in order to get the transaction completed. So in that instance, you could have 2, 3, or 4 movers that you're paying an hourly rate and they're sitting around doing nothing. If you think about it, that's probably a lot. That probably costs a lot more than $250 plus 1 day's interest. So to save money, and that's what a lot of people's concerns about bridge finance is that how much is it going to cost? It's more costly not to get bridge financing based on the fact you might not close, you end up with no property for the weekend, and or you're paying your movers just to sit around, which is probably as someone who's paying someone, I would be aggravated with just paying these people to sit around and do nothing. I want them to work. So always get bridge financing, just a much better solution when you're selling and buying on the same day or next days. Okay? Please talk to your clients about that and implore them to obviously get bridge financing, and also make them understand that when they are closing, I always ask my clients to get up by noon, but the time of closing, they have to be out no later than the time of closing, and they can't go to the property until it closes. I've also had that where some people think that they're going to close at 9 a.m. in the morning on a purchase. No, no, no. Please understand. You get the keys to the property at the time of closing, and it's never 9 a.m. Typical closings are between noon and 3 p.m. So it's always good to set the expectation with your clients as to when they can expect to get the keys for the new purchase property. The next clause I'd like to talk to you about is clause 10, the title clause. Now, clause 10 talks about providing clear and marketable title, free of any liens or encumbrances, mortgage, and such as that. But I want to talk to you about here about encumbrances. What is an encumbrance? An encumbrance is a claim against real property by a party that is not the registered owner of that property. And encumbrances are registered on title. So when we do a title search, we see those encumbrances registered on title. And actually, so do you. So when you do a geo warehouse search, you'll see the legal description, and you can actually see in that description if it says T/W or S/T. So here on our screen, we're showing you T/W means together with, S/W means subject to. S/T, means subject to. And so in this image here, we have the dominant land, which has a easement across the servient land to get to the water, the beach access. This is called deeded access, okay? And so the dominant land on its legal description would say together with easement 1, 2, 3, 4, and the servient land would say subject to easement 1, 2, 3, 4. And that would explain the easement goes across that land. Now, there are really two different types of encumbrances. One is an easement, and the other one is a right of way. Now, an easement is something that is registered on title that allows for something to remain fixed to the land. An easement is something like a fixture on land. Imagine this, a utility line. So a utility line comes from let's say the hydro box to your property, or a bell line comes across your property. There's going to be an easement in that part of the land that allows that hydro line or that bell line to be on your property. Whereas a right of way in our diagram here would be a right of way. The dominant land would have a right of way across the servient land to get to the water. And it's important to know that easements can affect how properties are accessed, obviously in our picture, right? And who can access your land, even though they don't own your land, whether or not people have a right to access your land. So where do you find the legal description of a property? Well, in Geo Warehouse. So the legal description is an essential, unique identification details that is on the Geo Warehouse. So looking at Geo Warehouse here, you go obviously open up your Geo Warehouse client report, you view the property details, and underneath the picture, you'll see it says legal description. So that's where you're going to want to go when you look at properties. You're going to not just look for the names of the people on title, but you're going to want to look at the legal description. And when you're looking at the legal description, you want to look for S/T or T/W. And that will tell you whether or not there's an easement on this property. Here we have this property. We see it has a legal description, which indicates S/T 1240437. So the 1240437 is actually the instrument number. So that's the number of the document in the land registry system. So the next thing what we do is we actually want to look at that document. So here I have a copy of the document we pulled for you. You just see up here on the transfer deed, document number 1, it says 1240437. That's the document. And then I pulled the schedules to that document. So we look at the schedule, and the schedule indicates what the easement is. It's an encumbrance. It says subject to a right of way, and then it says commencing, and it says the distance of 7 feet to a point, and then a distance from that point of 90 feet, then a distance of 3 feet, then a distance of 90.5 feet. So this is actually delineating where the right of way is on the property. And so key terms to know, obviously subject to, meaning the property is encumbered. When it says subject to, that is the property that is encumbered. That is the property that has the easement on it or the right of way on it. Okay. The right of way, obviously, an ability to pass over property. commencing, the starting point, and thence means then. Okay. And so looking further at the schedule, so we know where the easement, excuse me, the encumbrance, the right of way is located. Well, what's the effect of it? Well, we see here, and it's been nicely highlighted for you. It says to have and to hold unto the said grantee her heirs and assigns to and for her and their sole and only use forever. So this is a grant allowing the recipient of the grant to use this area of the land forever. Further on down it says, and it shall be quiet possession and no encumbrances, no further encumbrances. So quiet possession means that the servient owner of the land can't say anything to the dominant because it's quiet possession. You got to leave them alone. And what that means is you can't fence it in, you can't barricade it, you can't stop them from using it, and such as that. So what we have here is a picture. Looking at the picture, you're going to see on the left the servient land, and on the right, you're going to see the dominant land. The servient land's property line actually ends on the right-hand side of that blue line. So everything over from the blue line over is the servient lands owned by the servient owner, right? But the dominant has a right of way to use that triangle piece. So they have the ability to use inwards of the servient land. Now, this right of way actually came about because there used to be a garage in the back. Now, if you look closely at the picture, there's no garage anymore. So the dominant had paid the servient to be able to drive through there to get to their garage. But now that garage is no longer there. But that right of way is still there. The fact that the purpose does not exist anymore does not extinguish the right of way. The servient would have to buy or negotiate or get the dominant to release that right of way. And in this instance, my client, actually, this is an actual real file. My client, I received a firm agreement of purchase and sale. My client did not know about this right of way, and they were buying the servient land. So they looked at it, put it off on the property and think, great, look at this. I have two parking, one or two parking in the carport, and then, two parking on the side here. So they were thinking they were getting potentially 4 or 5 parking spaces. Well, obviously we search title and we bring this to their attention. No, no, no. There's a right of way here. You actually only have those 2 spots that we see up for the servient land. That actual area of the right of way is to be used by the dominant. You can't even use that portion of your land. And even though it's your land, you own it, and there's no reason for the dominant to even have that anymore because they don't have that garage. That area is to be used solely by the dominant, and it continues. So if the dominant owner sells and a new dominant owner comes in, the new dominant owner gets that area still. Just as my client bought from the servient, well, they're still stuck to that right of way because the right of way is registered on title and it runs with the land. It continues from purchaser to new purchaser. Okay. So the important part is that this right lasts forever unless it is extinguished or bought out. Okay. Now, what does the agreement of purchase and sale about this? So here we have clause 10 of the agreement of purchase and sale, which says that provided that title of the property is free and marketable, and so I'll paraphrase it. It says that the seller has to provide free marketable title to the buyer unless the buyer is informed of something registered on title. And so this clause 10, is to protect the purchaser. It means the seller has to deliver marketable title free from any unpermitted right of ways. And if the right of way is not disclosed in Schedule A or somewhere else in the agreement of purchase and sale, then it cannot exist on closing. And therefore, if the right of way was not disclosed, then what happens, and the buyer finds out about it, even if the deal is firm, the buyer could walk away from the transaction, provided it's prior to closing because we do a title search. But the buyer could refuse to close and or cancel the transaction, get the deposit back, walk away, or they could require the seller to buy out, negotiate, or get the right of way extinguished with the neighboring property, right? And very often it's quite a process to actually get the neighboring property to extinguish and give up a right of way because they use it as a parking spaces. So they have some value to it. It creates value for the dominant, right? And so in this instance, client came through, and so we were stuck in the position where, hey, there's this right of way on title. We think you need to know about it. What does case law say on this? Case law, here's the leading case on this, and it says that the existing of such an easement is to be disclosed in the agreement of purchase and sale. And if it is not, the purchaser is given the opportunity to rescind the offer. And it also says that the purchaser doesn't have to give a reason why they wanted to rescind it. Like, oh, well, this isn't going to be good because I need these park spaces. No, purchaser doesn't have to. It's strictly, was it disclosed? Did the purchaser know about it or not? That's it. So how do you disclose it? Right? Well, disclose it by putting it in the agreement of purchase and sale. On your legal description, put the entire legal description. Every single word of that legal description needs to go on page one of the agreement of purchase and sale. Now, if it's too long, or you could also put it on a schedule, right? But make sure every single character, S/T, every single character is line for line, word for word, character for character, put on the agreement of purchase and sale. It has to be exactly as on title. And if you do that, that is considered constructive notice. So even if the purchaser did not look at the legal description, do their own due diligence, the fact that it is on the agreement of purchase and sale gives them constructive notice, so they can't walk away from the deal. So that if you're representing a seller, make sure you put the full legal description in the agreement per sale. Now, if you're representing the purchaser and you see on your Geo warehouse search S/T or T-W, then you need to do some further due diligence. And where do you do that? Onland.ca. So we see here www.onlan.ca. And so what you do is you first start off, you have to choose your land registry office. So in Waterloo is the land registry office 58. So you put in 58. Then what we see here is you're given the option to search by either the PIN, the address, the instrument, or the map. So we know the instrument. We know the instrument is 1240437. So search by the instrument. That's the easiest way possible. Now, that's a really old instrument. Most instruments would now have, for instance, Waterloo region. So it's a WR 1234567, right? But anyways, put that instrument number in, and then it's going to give the property information. And on the far right, there's a drop-down menu where you can select how you want to pay. And so you see that here. Make that payment, and then you will actually get a copy of the documents I just went through. You get a copy of the actual deed, and you'll get a copy of the schedule. Look at those documents and try and figure out what's going on. Now, if you're having trouble with that, send the document to me and say, hey, Geoff, can you please help me review this? And I know it's old English, fence and commencing, and it talks about easterly and minutes, right? If it's a little bit difficult, feel free to reach out to us. But the other option that you could do is actually just throw it in AI. Throw it in AI and ask it to explain it to you. And that's what I would suggest as a starting point. Throw it in AI and ask it to explain it to you, okay? So key takeaway here is that if you do see S/T, when you do your due diligence, make sure as a seller, you put your full legal description in the agreement per sale. And as the purchaser, do your due diligence, go onto online and pull the necessary searches for your clients to make sure that there's no concerns. And also then advise your clients. It requires informed consent. So your clients must know about this, okay? Now, there are other types of easements that you might see. Another type of easement you might see in the legal description is called an easement in gross. So if you look at the legal description here, it says Lot 29, Plan 58M657, subject to an easement in gross. Now, an easement in gross is not an easement from one property to the next. Actually, an easement across many different properties for a third party. For instance, as in our example here, utility wires, right? That's for everybody. Utility wires is for everybody. Bell hydro line running across the backyard of everybody's house. That's for everybody. Easements in gross, okay? Easements in gross, you still want to search also. And the reason why is because a lot of easements in gross have building restrictions saying you can't build within the last 3 meters of your property because there's a hydro wire running back there or a bell line right there. And I have an example of that where I actually had a client. I got a firm agreement purchase and sale. We did the title search. We saw this easement in gross. We pulled the search and we found out that there was a building restriction on the very back of their property. They couldn't build on the last 3 meters of their property. These clients were quite upset. They actually wanted to put an in-ground pool in that property. That's what they bought it for, and a nice backyard for which they felt in-ground pool would fit. But because of this easement in gross, they were not able to build that in-ground pool there. Okay, just give you an example here. Now there are other easements you're going to see. Another easement you will see is on a condo. Now condos have all kinds of easements on them, and the reason why is because the condo, if you think about it, is like especially a high-rise condo, or it's a one plat of land where everybody has ingress and egress, vehicle egress over part of it, and ingress access to hydro wires going everywhere. So condos are a little bit different. You typically don't want to search a condo for easements just because there's going to be so many of them. Okay, so you should be safe to say that you don't have to search for encumbrances, easements, right of ways on a condo. Same with builders, brand new builds. So builders put easements on their brand new builds, and you can look for a builder easement based on the wording. So we have here it says the builder easement. What you're going to see is it's an entry easement subject to a right of entry, and then it gives you an expiration. So these are easements that allow the builder to come back onto the property to fix something, right? So maybe they have to come back and do some sod work, or maybe they have to come back and do some grading work, or maybe they have to come back and do something as per the tenant warranty. This is an easement that allows them to come back on that property for a duration of time. Okay. Now these once again, you don't have to worry about them. Okay. You'll see the expiration date on them, and you see, okay, that's a builder easement. The only thing that is important to know is these ones actually expire. And so if you're buying a resale home and it has a builder easement on it that has expired, well, that is something that we would catch when we're doing our title search as the purchasing lawyer. And we're going to requisition, meaning tell the selling lawyer to remove that easement off title. The other side is, let's say I have a client who purchased the property and the easement hasn't yet expired and they're now going to sell the property. Well, I typically will tell them when they're purchasing it, provided the purchase, hey, you got an easement on title. It's going to have to be removed from title once it expires. And there is a cost to that, of course. So, okay. But once again, these are the type of easements you don't have to worry about. So really what you're looking for is you're looking for those subject tos and the easements in gross. Make sure you put the full legal description in your agreement of purchase and sale, and make sure you do your due diligence by going to OnLand and inform your clients of what you see on title. Okay. Now, moving on to clause 26. Now, clause 26 is one of the most used clauses by lawyers amongst each other. So this is a very powerful clause that we use when we are negotiating over a transaction or a closing. So very often what's going to happen is on the MLS listing agreement, the property will say it's 3,000 square feet, it's 4 bedrooms, it's 3 bathrooms, the roof is 3 years old, the windows are 5 years old, or some other details that have been represented in the MLS listing, right? That's what it is. It's a list of representations about the property. Here's what the property, the features of the property. Now, let's say we come on, the final walkthrough, and we discover that that roof is actually not 3 years old; it's 10 years old, right? Well, this is where clause 26, agreement in writing, comes into effect. Agreement in writing, another is called a merger clause. And so what this says, and if you actually read it, the second sentence of it says, this agreement, including any schedules attached hereto, shall constitute the entire agreement between the buyer and seller. There is no representations, warranties, collateral agreements, or conditions which affects this agreement unless they are part of this agreement. So it has to actually be right in the agreement to affect the agreement. So if it is not in the agreement, it doesn't affect it. So something that the seller said verbally does not affect the agreement. Something that is listed in the MLS listing does not affect the agreement unless it is transcribed, written into the agreement. So, and like I said, this one comes up all the time, and very often between lawyers, we fight on this one. Like, well, hey, it's not an agreement of search sale. There's nothing we can do about it. So to protect your clients, add the MLS listing as a schedule to the agreement of purchase and sale. Add it as Schedule C. I actually, for any property I purchase, I always add the MLS listing as Schedule C. So this way, anything that the seller says in the MLS listing forms part of the agreement of purchase and sale. And I can rely on that and hold them responsible for that. Say, hey, no, no, you said this, 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 this. This is now part of the agreement of purchase and sale, right? Whereas if it's not, if you don't attach that on this thing, you can't hold the seller to it. So clause 26, merger clause, make sure you add the MLS listing as Schedule C to your agreement of purchase and sale. Protect your clients. The last one I want to mention here is we'll go through our Schedule A clause. And, obviously you guys all know the standard clause. The seller represents and warrants that the chattels and fixtures shall be in good working order. Now I want to highlight some words here. Represents and warrants. Let's look at that word warrants. So warrants means it's a warranty. Okay? Warrants. Now there's a difference between a warranty and a condition. All right? A condition is an essential term of the agreement of purchase and sale. And so if a condition is breached, the innocent party may terminate the agreement, get the deposit back, and walk away from the transaction. And so in our example here, a condition was, let's say there's a condition in the agreement of purchase and sale. The seller agrees to remove the knob and tube wiring before closing. That's a condition. The seller agrees to remove the knob and tube wiring before closing, right? Now, if the seller doesn't do it, well, then obviously that's a condition. The purchaser says, well, this is an essential term of the agreement of purchase and sale. I'm not purchasing, I'm walking away. Then in that case, the seller can decide whether or not they want to like, hey, I'm actually going to do it, or I'll give you some money to do it, or we can argue for undertaking to hold back funds, or we can say, give us a credit on closing. There's so many different things. But in that case, because the condition has been breached, the purchaser has the ability to walk away. Now, compare this to a warrant. Yeah, when the seller warrants or the seller, it's a warranty. A warranty does not go to the root of the agreement purchase sale. It is not an essential term. Therefore, if a warranty is breached, the purchaser cannot walk away from the transaction. What the purchaser has to do is the purchaser has to complete the purchase of the property. And if they feel compelled because there's something that is not working, then they sue the sellers in small claims court or in court after the fact. So for instance, in our example here, a fridge is not working. Well, it was a warranty that all chattels and fixtures are in good working order. Therefore, the purchaser has to close. Now at Rabideau Law, we fight everything right to the end. I don't let anything go. I'm like a dog with a bone. But so in that case, I would fight with the other lawyer and say, hey, fridge is not working. We either want to hold back money or get a credit on closing, right? And in this market, we have much better chance of that. But let's say in a seller's market, it also turns on whether or not we can get the other side to agree, which I most times do because I fight hard for our clients. But that's important to know when we're looking at language in agreement purchase sale. A condition and a warranty are not the same. And a warranty means that the purchaser has to complete the purchase. There has been some instances, and it's happened on my side, where let's say there's a warranty been breached by my selling clients, I'll just outright reject the other side. Nope, we're not doing anything. Nope, you have to close. You can come after our client after closing in court. Now we don't always do this, and I only do it based on my client's instructions. But let's say if the purchaser was difficult and the client, like my client and the purchaser were not getting along, I'll gladly protect my client's best interest there and do what they instruct me to do. So in that case, we would say no. And in that case, the purchaser has to close. Obviously, as realtors, you guys know what happens in that instance. The purchaser's upset, and who do they look at to try and rectify the situation for them? They obviously look at you guys. They look at, oh, well, realtor, maybe you should buy me a new fridge, right? So we don't want that to happen, right? So if it's important to your clients, make it a condition. So I have a clause here. It is a condition of this agreement that all chattels and fixtures, including this agreement, shall be in good working order on the completion date. Boom. That now replaces the seller represents and warrants. It is a condition of this agreement purchase sale that all chattels and fixtures are in good working orders. Therefore, in that instance, the seller can't just say, no, too bad, you have to close. The seller actually has to now deal with the purchaser, right? They actually have to find a way to close because they are now in breach, right? The seller would be in breach, and the seller doesn't want to be in breach, of course. I also added in the second part of this condition. Now, the second part of this condition you can use in a purchaser's market. I don't know if you could use it in a seller's market. You're welcome to try, but at least the first part swap out that first part for the seller represents warrants, make it a condition. And then this next part is if any included chattel or fixture is not in good working order on the completion date, the seller shall provide the buyer with a credit on closing equal to the full replacement cost of a comparable new item of like kind and quality, including all applicable taxes and installation costs where applicable. So this just says, hey, if in the event that chattel or fixture is not in good working order, well, then we don't have to negotiate about it. We just go, what's the new fridge cost of the brick? Here we go. Here's the cost. You are now required under this clause to give me back this amount of money as credit on closing. Now, what a credit on closing is, it's where I'll give you an example. So let's say the purchase price of the property is $100,000, and let's say there was a $5,000 deposit on the property, no other adjustment. So in that case, we know the purchaser has to pay $95,000 on closing. A credit on closing is where we say, hey, let's say the fridge is dead, the fridge is worth $1,000. So now the purchaser minuses that $1,000 from the amount they owe, the 95. So in that case, the purchaser only pays $94,000. Much easier process doing credit on closings rather than, giving cash on closing or, like, hey, I'll go out and buy a new fridge and bring it to you, whatever. Okay. Credit on closing. Super valuable. And also never do fix it clauses. Like the seller agrees to fix this or fix that. It's never going to be fixed to the way that the purchaser wants. Just do a credit on closing. Always better. So that's your like I say. So coming back to the seller reps and warrants, make it a condition. If it is important to your client, make it a condition. So coming around, obviously you guys are all here with me today, and then when you're mastering the offer, um, you implement these changes, I assure you're going to get the accolades you deserve. You're going to stand out. You're going to get results. You're going to earn recognition, and you're going to earn more clients for it, and you're going to earn appreciation. I really appreciate you guys here being here with me today. Do you guys have any questions? I want to thank each of you for showing up today. It's great to see you guys. Thank you for turning on your cameras. Thanks for seeing face to face. It's always great to see your smiling faces. If you want to follow Rabideau Law, which I always invite you to do, we have great information that we're always sharing on our social media. If you follow our social media, I invite you to follow our social media because we have blogs that I write on social media, which are really informational because they're actually cases that I have actually worked on, files that I've worked on, or like matters that I've come across. So I'm like, hey, this is a good case for a learning opportunity for people. So I'll write a blog about it and post on our social media. So if you want really good informational content, help you with your business, help you understand if you come into a scenario, how to handle it, follow us on social media at Rabideau Law. Otherwise, our main phone number. We have our toll-free number, email, and website. Once again, thank you very much for joining me today. I wish you all the best, and I'm always here for your next move. And here's to your next big win.